Good afternoon. This is the House Appropriations Committee. It is Tuesday, May 26th, 2026. It's just after 1 p.m. And we are here to hear a different amendment than what we heard last week on S-193. We had an amendment all passed through, and then other things have happened since, and our amendment got attached, and then it got unattached and reattached. And I'm going to turn it over to Chair Lalonde from the Judiciary to explain where we are now.
All right. Thank you for having me. Martin Lalonde, representative from South Burlington, Chair of House Judiciary Committee. This is amendment draft number 5.1 brought by Representative Burdett and most of the rest of the House Judiciary Committee. Overall, what the amendment does is it puts in place an interim forensic and competency restoration program while we await the permanent forensic facility to be put in place. One of the major changes is it has more involvement of the Department of Corrections, still just in the security side, as opposed to the offering of the clinical services and treatment. That stays with the AHS and medical director. But this required some slight changes in the appropriations component of the amendment that we have here. So you would be looking at the fourth instance of amendment if you were looking at the document on page 2. And the latest language was also, there's two subdivisions, C1 and C2. Talking about C1 first, the latest language is mainly from a recommendation from Chair Teresa Wood of Human Services. And the point of that is to make sure that the Agency of Human Services can proceed with not just the feasibility plan, but any other necessary planning to take place for what I'll call the permanent forensic facility. Although they're not to actually essentially break ground construction or fit up, I guess that's the technical terminology, until there's further legislative action. So that's what C1 does, and that's slightly different from what left this committee last.
We wanted to be sure that that our language didn't prevent AHS from moving forward, that they might just say, oh, they didn't give us any money, so we're not going to do anything. So this was rejiggered to ensure that things kept moving.
So in C2 is new language, in part because of the interim. And it actually makes explicit what is probably implicit. You know, the first thing being that there isn't further legislative action necessary before the interim program is implemented. I will note that there's emergency rulemaking that by the end of the year, there's to be rules for that interim plan, but that is not to go into effect until July 1st of 27, which will give the legislature next session an opportunity to tweak the statutory language if necessary, depending on what those rules come out with. So, but nevertheless, in subdivision C2, it really is to ensure that they don't have to wait for further legislation to be moving on that component. The second sentence of that subdivision C2 specifically, frankly, was put in there to alleviate concerns that I heard from the VSEA, that they wanted to have somewhere a statement that this would not be proceeding without the appropriate staffing. And this seemed to satisfy their concern that they had expressed to me. So that's why, again, it seems like that's implicit, but they were more comfortable having that explicit. So
we have to do a straw poll. I don't know that we can do a straw poll on the section of the whole amendment, or whether we have to do a straw poll on the entire amendment, in which case we should probably do a little bit more about the amendment.
Sure. I'm happy to tell you more about the amendment.
Why don't you just, sort of high level, and then we'll get these.
Yeah, I provide a little bit of the high level so in the interim, we have individuals who are being held, who are not getting services, individuals who would qualify under the criteria for the forensic facility, that they're charged with a life offense, that they're being held without bail, or could be held on bail, that they're incompetent to stand trial, that they're not hospitalized. That's a criteria. But there are those individuals while we're waiting for a forensic facility that really meets all the requirements that we really want to see, which is not being in a carceral setting, not being in a Department of Corrections prison, that being really the main thing. We need to have it, that's not a clinical setting, the prison, that's not therapeutic. And you need that for this kind of treatment from what we understand and from testimony. But while we're waiting, we still want to give them some treatment. We want to do competency restoration. We want to treat their forensic risk, which is their propensity for violence or not. And this amendment allows that to happen. So for the permanent facility, there's language that says Department of Corrections really has this limited role, including supervision of individuals who might be released because they're not restorable and not dangerous. We still allow those individuals to be released, supervised. Under the permanent, I'll call it again, the permanent solution, DOC really has a secondary role for that supervision. Under the interim, they would have a primary role in conjunction with Dale or the Department of Mental Health. So those things are changed so that DOC, because the individuals are in prison, DOC will be providing the security for those individuals, supervision if they're released, and still the AHS medical director will provide the actual treatment and programming. So that's what the sections of Section 9 and 10, and also Section 11, which has to do with, let me make sure I'm looking at this right, which does a couple changes for, this is a provision that has definitions, again, in the underlying bill for the so-called permanent facility. It has a slightly different definition of what the forensic facility is. This is on page 20. So for purposes of this interim period, the forensic facility would mean that the interim forensic and competency restoration program that's established by emergency rules. So we're just defining that for this period up to July of 29. The only other change.
Each time there'll be a permanent facility.
That's the intent. Yes, that is the intent. And so the last thing is the actual rulemaking, which starts on page 24. And this really lays out what we're expecting by the end of December for the Agency of Human Services to provide for how are they going to do this in the context of the Department of Corrections prison. So it really gets into the details of how they will actually operate this in the interim. And again, critically, it would not be effective until July 1st, 2027, whatever rules they do come up with.
And there are emergency rules just to make it go faster?
Correct. Yeah.
I mean,
So, and then the last, a couple sections have to do with the sunsets and the effective dates again.
so it wasn't a strike all, but it was a lot.
It's like an ad for the most part. It changes a few, the first 1, 2, 3, 4 amendments or instances of amendment are changing the underlying bill, and the rest are really adding additions. Yeah.
To ensure that interim time that is taken care of.
Right.
Okay. Wait.
Yeah, I was just concerned about, DOC and human services being, well, they're one, but not in the lack of data that would show us how well we're working, these things are working. The outcomes,
Right.
we can properly track people with the outcomes and then also reoffenses or dangerous behavior. And I was looking at AI asking that question. And they said, yeah, we've lacked that system, but it says here that this is mandating a unified tracking system that will help with that. Is that correct?
I will have to defer to the legislative council. I don't recall that.
I don't recall.
Not there. Because, we have these separations between health and enforcement and imprisonment. And so they're not cross-talking, but, we're having people that, well, we already know there's some really bad cases where people have been let out some bad things have happened. But it'd be kind of nice to be able to track so that you knew, you know, what happened, what the prognosis was, and what the treatments were, and whether or not they remained treated, or were there recurring incidents that went on after the fact. That kind of data would seem to me would direct, really necessary to make sure that we minimize the risk to the public and make sure that we're achieving what we want in terms of rehabilitating people.
Right, right. So that's a good point. I mean, the thing is, at this point, it's going to be such a small population that presumably it won't be that difficult to track. We're talking about 5, 6 people. And there is the fact that we're pushing off the rulemaking. That gives us time to look at how things are initially working. We have the forensic facility itself, because of what I'd like to call the appropriations fourth instance of amendment. There has to be additional legislation that occurs as well. And for long term, certainly perhaps at that point, we'll have a little better idea of, well, what kind of data are we going to want?
I'm not suggesting that you do anything now, just wanted, there's something to have on the radar.
Sure, absolutely. No, well, definitely. I mean, how we try our best in Judiciary Committee to look back at how things are going that we've implemented. So,
John had a question also.
Yeah, I think, section 12, I think it's on page 25. Talks about perfect corrections, cooperative with information of the department's about persons released. At least of that.
yeah, and that was a issue.
Tracking,
Right.
right?
So that really is there was a concern raised actually in corrections and institutions that frequently BNC probation and protected individuals don't have ready access to information protected by HIPAA. And these particular individuals, part of their release orders are going to have medication requirements and the like. And this is to make sure that there's a way for the supervisor of Department of Corrections has access to that information. So it's a little bit different.
A little different.
Yeah.
Yeah. Thank you.
Trevor, do you have anything you want to add? I'll get the attorneys up here.
No.
Okay,
I've spent a lot of time chatting with folks.
yeah, and it's fine. Okay, that's not a roll.
If you don't mind, I have a bill on the floor too. So
Bill,
Good luck.
so I'll text you when we're done,
perfect. Thank you.
and then you're gonna be taking this up at 1:30?
Well, as soon as we have H606 is on the floor, which is our bill.
Okay.
That's done. Hopefully it's be done.
Okay, and then is it also going to Human Services?
I think no, I don't think that's going
It's just the two of us this time?
Yeah, corrections and institutions.
Correct, oh, I knew there was more, yeah, okay. All right, thanks a lot, Martin. Katie and Eric. Doing what? Katie, did you just do our?
Yes.
Okay,
I'd much rather do your piece first.
I think we've heard it, we'll go to the rest but I think we just need a pretty high level, you know, maybe a repeat of some of what Martin said, because we don't need to hear the whole thing in great detail, but all the people that needed to have worked on that, so. So
Great, all right, thank you. Eric Fitzpatrick with the Office of Legislative Counsel, here to give the committee a high-level walkthrough of the rest of the Representative Burditt et al. Amendment to S-193. And actually, a substantial amount of this you've already seen, because a lot of this reprints. And I noticed the chair was asking Representative Lalonde kind of this question. The reason that pages 3 to 24 of this amendment, the vast majority of it is repeated, is because it reenacts the same sections of law that are in the underlying version of the bill. But the ones in the underlying version don't go into effect. That's the effective date stuff at the very end of the bill. They don't go into effect until 3 years from now, 2029. The sections in this version go into effect now. And the difference is that as the chair of House Judiciary just explained to you, is that it's the role of the Department of Corrections. In the version that's going to be in effect now, and that's in place for the next 3 years, Department of Corrections has a greater role in supervising the folks who are released from the facility and providing security, that kind of thing. Because the idea is also in that interim, those emergency rules are promulgated, they go into effect this January. And then during that 3-year period until 2029, DOC has this involvement. But when the final facility becomes effective, you know, knock wood, in 2029, that's right, their roles, not completely done, but very different, in that there are guardrails on it, they provide some security at the perimeter, that sort of thing. So what we had to do from a drafting perspective was reprint all those sections, just put DOC in, in about 20 different times, rather than have 20 different instances of amendment, it's more efficient. And then in the provisions that go into effect in 2029, that DOC language is not there. So that's the big picture.
Okay, well, that covers most of the
It
pages.
does, it does.
Okay.
A couple other little bits that are kind of related to that. Look at page 1, for example, the legislative intent. You look at lines 11 and 12, you saw this legislative intent language actually previously. The one addition is on lines 11 and 12. It's making clear that this intent section, which sets out that limited role of DOC, this applies to the July 1st, 2029 facility, right? Because that limited role is the permanent plan that starts in 3 years. It's not the interim one that's now. So that's the clarification there. Similar over on page 2, you see that subdivision 12, that also deals with what's happening in the interim. In the feasibility plan, the House Corrections and Institutions want to make sure that for this interim period that they'd be looking at the possibility of people who would otherwise be in a forensic facility, which remember, it doesn't exist yet, right? But they would otherwise be in there, might be eligible for placement in an out-of-state residence where clinically appropriate programming can be provided. So that's lines 3 and 4. A similar line, the third instance has to do with the Agency of Human Services is required to provide interim status reports to the Joint Justice Oversight Committee this coming year, actually in August and November. And since the rulemaking provision was added to the bill, this adds that they want to hear back from them on how the emergency rulemaking is going too, because those don't go into effect until January. So now they have a couple of times to say, hey, how's it going? So that's that piece. You just looked at the fourth instance of amendment. That's the one that this committee is involved in that Representative Lalonde just explained. And then starting on page 3, this is and all the way to page 24.
We don't need to go over that one.
Yeah.
It's just the same language.
Same language. Emergency rulemaking as well, I think Representative Lalonde just talked about a little bit. That's section 12 on page 24. Again, line 10 is an important one there, just because it's this interim program that shall be effective on July 1st, 2027. Because remember, the rules are supposed to come in on December 31st of this year, but there's that 6-month window before the program itself becomes effective, because the idea was give the legislature some time to look at it and decide, well, we've seen the emergency rules. Is this what we want? Do you want to make any changes to it? It gives you a time window to do that before the interim program goes into effect. So that's really that. Yeah, that's really it. And the rules address a number of different things, as Representative Lalonde mentioned. Over on page 26, line 3, that subsection has to do with some general standards that emergency rules have to comply with. And I ran this by our Administrative Rules Committee Attorney, Damian Leonard, and he had some suggestions for me on this, and he okayed this language. So it makes clear that these rules do meet the standard for emergency rulemaking. And I guess interestingly, subdivision 2, which I never knew this, line 6, emergency rules are ordinarily only effective for 180 days. So the legislature can make them effective for longer, but you have to say so. So that's what this does. Makes it, because remember, they have to be effective for that entire 3-year period until the final plan gets set up.
Trevor.
So are they contemplating doing permanent rulemaking?
Yes, in fact, that is in the underlying bill.
Okay.
The one that goes into effect July 1st, 2029 requires permanent
You only
rulemaking.
have 6 months. You can repeat emergency rules.
Right,
You can't make an emergency rule longer than 6 months.
right, yep. Yeah, but the permanent ones are contemplated for once the final facility comes on board. And then effective dates and repeals are consistent with this sort of bifurcated structure that I was just mentioning. Where you have one program in effect until the 2029, and then the permanent one in effect thereafter.
So that's good. I mean, it makes a lot more sense to consider the whole thing and not just think about the building itself, but how the program's going to work in that interim period.
Yeah, I think it's,
So
yeah.
that makes a lot of sense to me. And then that changed our amendment. So Katie, do you want to I know you were doing a lot of back and forthing with, you had the littlest part of the amendment, but to get it right was required a bit of time. So
Sure, let me pull it up on my screen. I had it all teed up and then I was following along with you and I lost it. Let me find the fourth instance. There it is. Okay. Okay, so here is the language in question. This language in C1. So the concept has changed a bit. When you were discussing this previously, there was a conversation about really no expenditures other than for what was necessary to complete the feasibility study without a further action of the legislature. As the conversation evolved, there was a potential interest in maybe allowing some planning activities short of construction and fit up happening. And so this is what is authorized with this language. Funds appropriated to the Agency of Human Services and its departments in fiscal year 27 shall be used to complete the feasibility plan required by this section and any other planning activities necessary to implement this act. But absent further legislative enactment of the General Assembly, the agency and its departments shall not expend funds in fiscal year 27 for construction or fit up. And that's really the change that to your language.
Okay, is that clear? Questions?
Clear.
Probably better.
It's
Good to have a
fine.
little.
Yeah.
On that, okay. Great, so that's an amendment. Thank you, Katie. So we don't have possession of the bill, but we need to do a straw poll and on the whole amendment, and then we'll let Martin know what it is. So if there is somebody who'd like to make a motion to support draft 5.1. John, Wayne, John, there, knew it was gonna come up. Just anticipating. All right. Not seeing any further questions, the clerk is ready.
Blumley,
Yes.
Representative Dickinson,
Yes.
White,
Yes.
Representative Feltus,
Yes.
Representative Kaczynska,
Yes.
Representative LaRoche,
Yes.
Representative Wiki,
Yes.
Representative Nyberg,
Yes.
Coral, yes. Representative Stevens,
Yes.
Representative Nakavoni,
Yes.
Representative Shine.
Yes.
Looking 0-0.
Oh, and Trevor will once again attempt to report for our committee, and I guess you're gonna have to first withdraw
No,
the amendment or
I just have to take leave of the house.
do it, yeah,
So, and then it'll be theirs.
right, and then they'll take over, right. Thank you, Eric. Thank you. Katie, thank you very much. I will text Martin. That's what we have for right now. Keep your phones near, don't know what's gonna happen. Working on a few things. We're supposed to have a committee of conference. I don't know. I think we're not, but we might. So I'm gonna check out of that. And they're on the floor and I'm told there may be a roll call. So let's